that we have a lot of interesting events coming up. We have an event on 17th for how to get yourself published as a law student. And then we have a very interesting short course coming up on understanding case law, which is a free and non-monetary educational initiative designed to support aspiring and first generation lawyers. So in this course, there will be the duration will be of 1 week, and live lectures will be there daily of 1 hour at 8 p.m. And all the students who register will also have access to the recorded lectures as well. So in case if you want to go back and see the recording again, so you all can do that. Apart from this, we are also very pleased to inform that we will also be conducting a lot of quizzes, a lot of debate competitions, a lot of new events here and there. So please stay tuned for that. I am very pleased to welcome Jaanvi ma'am for today's session. Now I would like to invite Shifali to please take over. Thank you, Shifali.
Yes, ma'am. Thank you, ma'am. So we are pleased to welcome Advocate Jaanvi Sharma, a lawyer specializing in data protection and privacy law, with a strong foundation in global privacy regulations such as GDPR and India's Digital Personal Data Protection Act. She has worked with reputed organizations to advise on compliance, regulatory risk, and ethical data use. She is the founder of the Women Data Protection Foundation, an international NGO focused on empowering women in the privacy and cybersecurity space through mentorship and education. An alumna of NALSA, she holds an LLM in corporate law, a postgraduate diploma in cyber laws, and multiple international certifications. She brings a keen interest in the intersection of law and technology and has been featured as a speaker at national and international platforms. Advocate Jaanvi Sharma's work reflects her passion for advancing privacy, regulation, and supporting the next generation of legal professionals. Over to you, Jaanvi ma'am.
Hi everyone, how are you all? So let's keep this session very interactive, and I request all of you to just raise your hands in case of any queries. And if I ask you any question, I would recommend you to please use the chat box, and to give me a thumbs up if you are in the right location, and if you are what is the difference between these two, what is personal data, and what is DPDPA, and why DPDPA came, what was the need of DPDPA. And we will also be discussing about the key provisions of DPDPA, where I'll be talking about what are the legal basis for processing personal data, and what are the obligations of data fiduciary, what is data fiduciary, what is data processor, and what is data principal. So I'll start the session by asking, can you just tell me like how many of you are the students and how many of you are the working professionals, so that I can take the session in that particular extent. If you are working professional, so I will keep the okay, so most of you are just type if you are a student or a working professional. Okay, so I can see most of the people are students. So let us keep this session for like a very basic session, where we will be talking about the foundations and fundamentals of data protection, and what was the need of data protection law. So let me ask you a question first. So can anyone tell me, like, please raise your hands for this question. So can anyone tell me, is your password your personal data or not? Does it comes under the purview of personal data, or it doesn't come under the purview of personal data? This is the first question. And I would need the answer, like reasons also, why it comes under the personal data and why it doesn't come under the personal data. Okay, can anyone who said yes can tell me like why it comes under the purview of personal data? Just raise your hands, please. Okay, yes, Sahil, please go ahead. Can
Because the
yeah.
password itself is attributed to our personal information in itself. So anyone with the access to our passwords will also have access to all our other personal data and information which
But
comes in.
the person is not holding your username. They only have your this thing, only your password. Then how it can come under the purview of personal data?
And because essentially when the password being aligned to us, the when the password is also available to us, most of the time the username in itself, even though the person to whom it is attributed to, that will also come in the access of this person in itself, right? A person simply cannot hold the password without knowing who it belongs to.
No, I am just asking that you have written a password on some blank paper or on your notepad in your mobile phone, and your username is not written there. I'm just asking, is your password your personal data or not? I'm not asking, is
All
it
right, in as an individualistic data, I don't think it is.
okay? Yes, anyone who says it's a personal data after this clarification?
Ma'am, may I?
Yes, Ayushi, please go ahead.
I think password is a personal data because the account where we add some password, the phones where we add the password data contains some sensitive information. So it should come in the category of personal data.
Okay, Lalit, yes.
Yeah, hi, good evening to all.
Yes, good evening, Lalit. Yes, please tell me.
Yeah. So the password is fully covered and is personal data as defined in the IT Reasonable Security Rules 2011. So it is a personal data. In even your username is also personal data.
Okay, so right now we are just talking about the password thing, and we are talking in respect to DPDPA. So now I will explain why password is not your personal data, and why password is your personal data at the same time. So most of the people, they write password either some relative's name, either some family member's name, either some date of birth. And most of the people, they use robotic numbers, where they are just using some random numbers, the random symbols, random alphabets. Now what is personal data? Because now you guys must be thinking, what is personal data? So personal data clearly says that it is any information by which a person can be identified, or by which a person is identifiable, which means जिस इंफॉर्मेशन से आपको पहचाना जा सकता है, ये कंफर्म है, दैट इज ओनली एंड ओनली योर यूनिक डेटा. और कोई भी ऐसी इंफॉर्मेशन जिससे आप पहचाने जा सकते हो. व्हेन वी से आइडेंटिफिएबल, दैट मीन्स आप पहचाने जा सकते हैं. And when we say identified, that means that is only and only your unique data. So for example, your Aadhaar card, your passport number, and your phone number. So and your face, of course, your biometrics, of course. So these are the personal data which no one can have same like you. Everyone has different face, everyone has different biometrics, everyone has different Aadhaar ID, everyone has different passport number, everyone has different credentials on their voter ID card. Everyone pan id is different, everyone bank account details are different, and they can uniquely identify you. Now when we talk about the identifiable data, so that can be your name, that can be your blood group, then can be your religious belief, that can be your political belief, that can be your blood group, that can be any information, any medical information, by which it is not sure that you will be identified, but if we will mix two or three information, then we can identify you. So this is what personal data is. Both of these categories fall under the purview of personal data. Either the information is identified, or either the information is identifiable. So when we talk about whether your password of Instagram, Facebook, or any password is your personal data or not, then we need to see whether in your password you are using any of your relatives name, because when you are using your relatives name or any date of birth of your close ones or your family members or even yours, then you are putting the personal data elements by which that person or anyone can be identified. There is nothing like that it is risky or it doesn't come under the it is related to security. It is not like that. So that is it regarding the personal data. Is my voice not clear? Can anyone confirm me?
It's
I
clear,
think it's
ma'am.
clear. It's good.
Okay. So this is what personal data is. Now let us discuss about what is DPDPA and what was the need for bringing DPDPA. So can anyone tell me what is the need of DPDPA? If you can just raise your hands and tell me what is the need of DPDPA. We have two raised hands. Anyone else? Come on, new people. I don't want to listen from the same people again and again. I want this session to be very interactive, and we just have 40 minutes remaining. So, yes, Gayatri. Gayatri, do you have something to say? Okay, let us continue. So the need for bringing DPDPA, let's discuss on that. So the first need is to empower the individuals like us to empower the data principles. Now, what is data principle? So in DPDPA, any individual whose data is going to be processed is known as data principle. So individuals like us are known as data principles. So DPDPA is to empower the individuals, the data principles like us. And the another important aspect of DPDPA is to put some obligations on data fiduciaries. So now what is data fiduciary? Are the organizations who are processing personal data of data principles, which means the entity, the organization, or a legal person, if processing as in like if storing, collecting, and retaining any personal data of individuals like us, then that entity and or organization is the data fiduciary. So two major requirement for DPDPA was to empower the individuals like us, and the another one is to put some obligations on data fiduciaries. Now, when we talk about to empower data principles like us, so what does we mean by this? What is the requirement of empowering us? Can someone just throw some light on this? What was the need? Why empowerment is required? Yes, Aftab, can you please tell me?
Right to privacy is a fundamental right under Article 20. That's why.
Okay. Anyone else? Yes, Thanush.
Hello, ma'am. Am I audible?
Yes, you are.
It is to protect our data from being misused by some entity or corporates.
Okay. So let me put some, frame it more appropriately. So when we talk about the empowerment, then we are talking about to give some rights to individuals like us. Right now, can we ask the organization, what all personal data are you holding about us? Can we ask them the question that we want to see what all data you are holding? Please show us. Can we ask them to remove all our personal data? Can we ask them to erase our personal data? They will give you very excuses like we don't know how much personal data we are processing, we do not have some database, we it is not formalized. So they will give you such excuses, and such excuses are cannot be taken when cyber crimes are on peak, because on like behind every cyber crime the personal data has been leaked. That's the reason why cyber crimes are happening. Any fraud, if we talk about the cyber frauds, so why they are happening because your bank information, your banking credentials are on stake. They have been leaked by some system, they have been leaked by someone, they have been stolen, they have some data breach has been happened. So all of these aspects have been covered in DPDPA. So that is what meant by empowerment. So DPDPA give us the right where we can ask the organization to erase our personal data, where we can ask the organizations to forget our personal data, where we can ask the organization to have our data elements corrected, where we can ask the organizations for grievance redressal, where they need to provide a grievance redressal officer whom we can complain if our data is being leaked. When I say the obligation, so I mean the responsibility of data fiduciaries. What would be the responsibilities of data fiduciaries now? So now if we say the organizations that please delete our personal data, please give us access of our personal data, so we always get to listen, we don't know where your personal data is and we can't give you your personal data, it is a long process. So now government has made it mandatory under the thing is in key obligations that organization have to obtain a valid consent from users unless allowed under the legitimate use. Now what is legitimate use? When we talk about legitimate use, then those are the exceptions under the DPDPA. DPDPA says that organization can only process your personal data under two conditions. So first condition is the valid consent. Now when I say valid consent, so that should be free, that should be unambiguous, that should be unconditional, that should be clear, and that should not be under any force. So this is what a valid consent is, and I feel all of you are from legal background, so you know it more than me what is a valid consent. Now when we talk about the legitimate use, so under DPDPA there are certain clauses mentioned. So legitimate uses, if someone has voluntarily given their personal data, so consent has not to be taken. If someone get ill or due to some medical emergency, if data is required, then you need not to take the consent. If it is for public estate, if it is for welfare of public estate, I'm sorry, if it is for national emergency, if it is for any subsidy which you have already given the consent, then it, in that case also, again and again, taking a consent is not required. The apart from it, we have the employment clauses. So if for employment purposes, if employer want to process the personal data of employees, then consent is not required. Now the another obligation of data fiduciary is to ensure transparency by providing a detailed and clear privacy notice. When I say a detailed and clear privacy notice, so a clear privacy notice means that every single individual should understand what is written in the privacy notice. It should be in a very, very simpler language. Also, DPDPA mandates that you have to provide the privacy notice in 22 languages, which are mentioned in Schedule 8 of Constitution. So India is a vast country and we have so many dialects, but only 22 languages are well recognized. So in those 22 languages, you have to provide the privacy notice. The another thing is, organization has to respect the privacy rights which are given to data principals under data protection law, and they also need to facilitate them, the user rights, in a very, very easier way and very friendly, user friendly medium. So rights, as we discussed, that right to access, right to create correction, right to erasure, right to data portability, right to nomination, right to grievance redressal. So these are the rights which are mentioned in DPDPA. Now the another obligation is to maintain security safeguards. Now when I say security safeguards, so I mean by this is that organization has to take some technical security measures, which means you have to need to have the data in an encrypted form. You if data is in rest, then also it should be encrypted. If data is in transit, which means if data is going from one place to another place, then also that media, that transition should be encrypted. And if it is in a channel, so that in that format also data should be encrypted. Now another thing which has been mandated is that there should be regular audits, because when audit will take place, then only we will be able to know what are the loopholes in our organization, what other measures we can take. So this is another technical measure, and there should be a minimal retention only for the purpose for which until and unless purpose gets fulfilled, or if it is mandatory under the law, because this is also one of the exception, if it is for judicial reason or under the obligation of law. So for example, income tax come under the purview of legal obligation. RBI guidelines says that you need to store the data for 10 years, so that also comes under the legal obligation. So for that purpose only you can store the data for as mandated by the law. The another obligations which DPDPA has made is that you need to report any personal data breach to the data protection board and the affected users. When we say affected users, so data principals who have been affected or whose personal data has been leaked, the organization have to inform them as soon as possible, but no later than 72 hours. If you will inform after 72 hours, then you will be imposed with penalties. We will discuss at last what are the penalties after discussing all of these things. Now the other important terminology is the data processors. So when we talk about data processor, then what does it mean? In data fiduciary, we have discussed that any organization or any entity who is deciding the purpose and means of personal data. Now, purpose and means, these are two very, very important terminologies. When we say purpose, that means why. Why are you processing the personal data? Why are you collecting? Why are you storing? Why are you retaining? And why are you transferring? Why are you sharing? So that is the purpose of processing any personal data. Now when we say means, so that means how are you going to process the personal data, what would be the medium of processing the personal data. So these are two important terms, why and how. Now when we talk about data processors, so data processors are always the third parties, they are always the vendors. Data fiduciary can never be a data processor. This is the so many people ask this question, so I want to be very clear since beginning. A data processor is someone who process personal data solely on behalf of data fiduciary. A data processor is a third party, you can say it's a vendor, and he can only process personal data as per the instructions of data fiduciaries, and they can never decide why and how data has to be processed. Now, what are the obligations of data processor? So data processor can only follow the explicit instruction of the fiduciary. They can never and ever take any decision for why and how. I'm so sorry, my throat is not that good. Yeah. So we were discussing about the data processing agreement. So this is what the data processing agreement looks like. And also, if a processor wants to appoint some another entity, which is known as sub-processor, so in that case also, processor has to ask the data fiduciary, and if data fiduciary is not giving permission for it, then in that case the processor cannot appoint the sub processor to process the data on behalf of the processor. So this is what data fiduciary means, and this is what data processor means, and we have discussed the obligations of these two entities. So this is the very important aspect of today's session. And now, if any questions till now, then we will move ahead. Any questions, any doubts? Come on, guys. Are you guys sleeping? At least raise hands, at least give me a thumbs up if any issues or if you are not understanding anything. Okay, shall we move ahead? Yeah, we will discuss about the penalties. Sure. So let me do one thing. Let me just quickly come or discuss about the penalties that are mentioned under DPDPA. Then we can talk how law students can build their career in data privacy domain. I myself is also an advocate. So let us quickly wrap this up. So I feel there's no confusion between what is data fiduciary, what is data processor, and what is data principal, because these concepts are very important. And I feel what is personal data is also very much clear to all of you, because the complete DPDPA evolves or roam around these three terminologies, which are very, very important. Now let us discuss about the penalties. So can anyone just tell me what is the maximum penalty which is mentioned in DPDPA? Is it 50 crores? Is it 200 crores? Is it 150 crores? Is it 20 crores? What is the, or is it 2%? Can anyone just quickly tell me?
Ma'am, it is 200 crores. 250
Okay.
crores, sorry.
Okay. Anyone else? Okay, as everyone of you know that the highest penalty is 250 crore. Can anyone tell me for which of the offense the highest penalty is there? What is the name of that particular offense for which the highest penalty has been there? Is-
Ma'am, it's failure to implement security safeguards.
Okay, I know most of you know what are the penalties. Still, to all who don't know about it, so the maximum penalty is 250 crores, which is a very well said that it is for breach of security safeguards. So, for example, if data fiduciary fails to encrypt encrypt any personal data, or some major this thing happens, data breach or data leak happens, then the maximum penalty will be imposed, that is of rupees 250 crores. Now the another we will talk about a lesser penalty, which is rupees 200 crore. So as I already told you that if any organization fail to notify the data protection board of a data breach, then it is also an offense, because data protection board clearly states that you have to inform about the data breach as soon as possible before the data breach reporting is made. So if company delays a data breach reporting after discovering the data breach, so what this after discovering the data breach means here, so it may be possible that data breach has been already happened a few days back, but you were unaware about that data breach. So in that case, when you will be aware about when you will discover about the data breach, from there 72 hours start, and you have to inform as soon as possible when you come to know about the data breach, and but it should not be any later than 72 hours. So this is 200 crores. And if any organization fail to fulfill the obligation about the children's data, now you must be thinking like, what does that mean? So there are so many ad tech organizations which take children's consent for giving them some educational content. So they have to make sure that they are taking the consent of the parents, and if they are not taking the consent of parents, then penalty of rupees 200 crores will be imposed. Now how this thing can be taken care of? So there are so many tools available in the market, which are the consent management tools. So you need to have some management tool which can easily can be integrated in any of your process, or in any of your current tools. So that thing can be done, and there are so many tools in the market like Privy's tool is there, Identify, and other small organizations are also coming with their own data management tools. The another obligation is for significant data fiduciaries. So that is for rupees 150 crore. And if any organization is not maintaining the obligations of a significant data fiduciaries, now what are the obligations of significant data fiduciaries are? So they are a significant data fiduciary, it is mandated that they need to have a data protection officer. And if they are not having a data protection officer, then they will be imposed with this penalty of rupees 150 crore, which is a lot. And if they're not doing the regular audits, regular DPDPA audits, or DPIA, or if they are not omitting the skipping the large annual audits, so rupees 150 crore will be imposed. Now the lesser amount is 50 crores, which is if there is any failure to fulfill data principal rights. So as I told you, there are few rights, which is right to access, right to correction, right to erasure. If any organization refuses any user or individual to their request, which is to delete the data or access the data or export the data, then a penalty of 50 crore will be imposed. It's just that the individual has to inform the data protection board. Now, if any guidelines or any measures has been given to any organization by the board, by the DPB, once it will be established, and the organization is ignoring or delaying those corrective actions mandated, yeah, that may be after a breach, that may be just like there was about to a breach to happen, they are not taking the proper security measures, due to which a breach can happen, then a penalty of 20 crores will be imposed. Now, last, but it is very important for all of you, because you, being data principals and the responsible citizens of India, cannot give your false personal data. You cannot raise any false or deliberate grievance request, and if you are doing so, then you will be punished or penalized by penalty of rupees 10,000. So this is about the penalties. Anyone have any question about the penalties? Yes, Sahil. Please, can everyone now use the chat box to write their doubts and queries? So we have 10 minutes remaining, in which we will be discussing about what are the options for law students who want to pursue their career in data privacy. So the first thing which all of you can do is you can reach out to some consultancies, you can reach out to some law firms who are taking the data privacy work in their organizations and firms. Now, when we talk about the data privacy work, so that means creating ROPA, that means doing the data protection assessments, which consist of ROPA activity, which consist of DPIA, which consist of TPIA, which consist of LIA. So these are the assessments which every data protection professional conducts for an organization, to check like whether the organization is doing the right thing which are mentioned under the law, or whether the organizations are not doing that thing. The another thing is that there are so many I just told you that you need to have the data processing agreements, and in every contract or in every agreement, if that is not even related to data protection or if that is not a data processing agreement, still the privacy clauses are to be there, where we will be putting some obligations on our vendors or on our clients, that you have to take care of the personal data of our like if anything we are providing them, if we are taking any services from them, if we are integrating any tool of theirs, so they cannot disclose any personal data without seeking our permission. They can only disclose the personal data if it falls under any exception which we have discussed in legitimate uses. Now, these are the two major things which every law student is required these days, because organization wants someone who can understand the law, because after all, DPDPA is a law, and the lawyer's mind is required to interpret the law, which an engineering student cannot do, but it consists of lot of technical terminologies, for which I would recommend all of you to start reading some blogs, find out some research internships. Now, when I say research internships, so they are very important, because without doing a research internship, I don't know how will you be able to perform those activities on field. Because first of all, you need to research what is exactly these assessments, or what are the instances where personal data will not be personal data, where controller will not be the controller, where processor will not be processor. And it is a niche area, and so many things, so many new things to learn. And we can say that it is amalgamation of technology and law, so many new things to learn. And if you guys want to start, if you are female, so we can also help you at WDP Foundation, because it is solely for the women who want to build their career in data privacy, who are very serious about data privacy, or those who are currently working in data privacy. So that's it from my side. If you guys have any questions, we can take the questions. Yes, Sahil, please.
Ma'am, alongside the questions that are asked in the chat box, I had two specific questions as to the DPDP Act provisions. Would you be kind enough to take them?
Yes, please tell me.
Yeah, right. So I'm very sorry because they are not exclusively dealt in this session by you, but they are part of
Hmm.
DPDP, which I really wanted to have clarification on. Firstly, thank you so much for the session. Now, ma'am, in DPDP, in the definition of data, we also have automated data included in it, right? However, in the whole of DPDP, there is very little legal backing behind this automated data or protection as per se. So my question, first question that was there is, if a government tomorrow decides to incorporate a automated AI model for any kind of social welfare scheme, be it healthcare or whatever, and then there is certain discriminatory behavior found in this automated AI, like they have arbitrarily removed some person, etc., etc.,
Hmm.
what is the legal backing behind this that can be sought after? This was one question. And should I ask the second one, or would you answer this first?
No, very nice question. You can ask me the second question also.
Thank you so much, ma'am. The next one was that we also have provisions of transnational data transfer in DPDP, even though it's quite restricted. So my question is attached to this first question itself. Now, most of the time, like you said, the data processor and the data fiduciary cannot be the same. So in a social welfare scheme, the government is the data fiduciary. Now, the data processor is generally this AI, which is processing this data, right? So this data processor, let's say, is from a outside country, be it Spain or France, whatever. So now this country or this individual is having this, processing this data and having the control of it. So what is the allowance or governance over this transnational data sharing that is taking place between these two entities?
Okay. So I'll answer both of these questions in like two or three sentences. The first thing is government has been exempted from DPDPA on any of the decision which government is making, on any of the processing which government is doing, or any transfer. Like if we talk about the processing of personal data, so all the entire life cycle of that personal data comes under the processing. So any aspect of that, either you are storing the data, either you are collecting the data, either you are transferring the data, either you are deleting the data, so government is exempted from that thing. And now DPDPA is a baby, and there are so many gray area and loopholes in DPDPA that you clearly highlighted in your first question. The another thing is that when we talk about DPDPA, so it is more for the business, it is more for to get some business with countries outside India. So that is what the whole mission, vision and aim of DPDPA. So it will definitely not going to cover in next 2 to 3 years about your first question, because it will then limit a lot of business. So it is for the benefit of business only.
Yeah, hi, Advocate Jani. Can you please throw some light on using of data by lawyers, as we are on a routine basis handling data with of clients, including the personal data, financial data, their banking details, etc. So can you throw some light on that aspect?
Yes, sure. So now, if the information has been voluntarily provided you, if some client comes to you and they are voluntarily providing their information, then of course, being a lawyer, you need to understand that there should be some evidence. Tomorrow your client can say, I have not provided that. So now what is the evidence? If you have registered the case in the court of law, and your client has also appeared, then it clearly says that your client has voluntarily provided all the details about that thing. And another thing which you can of course do, you can get a agreement, or as I said, you can have a contract signed with the individual, with your client. And if you are a law firm, then of course you need to do these these tiny things of getting a agreement signed, and to have some evidences that okay, this particular person has given us right to process the personal data. And in those cases also, there is a difference between a data fiduciary and a difference between the independent the independent person. So if you talk about the lawyer who is taking the cases, then you are just a independent service provider, you are not a data fiduciary in that case.
Hello, ma'am.
Yeah, thank you so much. Thank you so much.
Yeah.
Hello, ma'am.
Yes, Kanak, please tell me.
First of all, a heartfelt thank you to you for such an insightful and thought provoking session.
Thank you very much, Kanak. Yes.
Now, with your permission, I would like to begin the audience questions segment. We have
Okay.
received some interesting and relevant questions from our participants in the
Mhm.
chat box. First of all, I will addressing from the chat box. So, first question is, ma'am, if the particular organization can't afford that amount of penalties, is government be liable to pay?
No, because you are liable to pay the government. You are not liable to pay any individual whose data has been leaked, or whose personal data is with the cyber criminals. You need to pay this amount, this hefty amount to the government, and it's on you how you need to do that. Either you need to sell your company, or how you want to do that. It's on you. It's only and only the organization's liability.
Okay, ma'am. Next question is, does the data principal has any kind of control over data once given by him? Can he or she get it deleted or has any say in questions of selling or transfer of data? If yes, then how?
So, so that's what we have discussed in the session, that there are certain rights which have been granted to data principals in DPDPA: right to deletion, right to access, right to correct the personal data. So this is what we have discussed in the session.
Okay, ma'am. Next question is, what are the gray areas or ambiguities in the DPDP Act that might pose litigation risks or enforcement challenges in the near future?
There are so many gray areas, and gray areas are in all the laws. It is not just specific to DPDPA, but in every law gray areas are. And I don't think that I should talk about this about this upcoming law, the gray areas and all, in any such public engagement. I am very thankful to government that they came up with such a wonderful law, because it's a very important, and it's a first step. It's the first comprehensive law which is giving protection to data principle, even if in certain limits it is, but still it is better than not having anything.
Okay, ma'am. And the next question is there any direct recruitment after DPDP Act's rule implement, especially in Data Protection Board of India?
No. So in Data Protection Board of India, they will only hire the senior people, those who are retired IAS officers, and not anyone else.
Okay, ma'am. Next question is cross-border transfer and international issues, DPDPA compliance.
I didn't understand this question. Kanak, we can just take another one question, because we have just 1 minute remaining.
Okay, ma'am. So the last question is how is DPDPA different from GDPR?
So DPDPA is, I would not say that it is very different from GDPR. So the basic differentiation is that GDPR is a European Union specific law, whereas DPDPA is an Indian law. And in UGDPR, there is no right to grievance redressal. There is no right to have the nominee. These are the two rights which are not mentioned under GDPR. And if we talk more about it, so there is no consent manager in GDPR, and there is no such thing such as you need to give the privacy notice in 22 languages. So these are the basic differences which is in between GDPR and DPDPA.
Okay, ma'am, I completely got it. Now I would like to invite my co-volunteer Sneha for thanking vote.
Sure. Thank you very much.
Good evening, ma'am. Good evening, everyone.
Hi, good evening, Sneha.
Thank you so much, ma'am, for today's session.
You are
I
welcome.
am Sneha Priya, a law student, a volunteer from Event and Program Department of the Collective Council. It's an absolute honor to be part of today's session, and I am truly grateful for the opportunity to engage with such accomplished professional and curious learners. On the behalf of the Collective Council, I extend my heartfelt thanks to all of you for being part of this insightful session. First and foremost, I would like to express our deepest gratitude to our distinguished speakers, Advocate Jaanvi Sharma, a lawyer specializing in data protection and privacy law. Thank you for today's session, ma'am. We are grateful to have a session with you. Thanks to our organizing team at the Collective Council. Thank you for tireless effort behind the scenes, for planning and communication to execution and coordination. Your dedication is what made this event a success. Before we end, we kindly request all the attendees to find and fill out the feedback form. Your thoughts matter grateful to us. Certificate of participation will be provided to those who complete the feedback form. Thank you once again, ma'am, for this session and for your precious time. Thank you, ma'am.
Thank you very much, everyone. And if you guys have any question, you can anytime reach out to me. These are the details on which you can reach out. Thank you very much. Have a lovely day ahead. Bye-bye.